Today we will learn about the judicial branch, or the court system, specifically the different types of federal courts. The federal court system of the United States consists of three different types of courts. First, there are the district courts. The 90 district courts are the lowest level of federal courts and are scattered across the United States. 80% of their cases are civil cases between people from two different states. The district courts also hear criminal cases in which people are accused of breaking federal laws. These are usually cases involving mail fraud, stealing mail, counterfeiting, just printing fake money, or distributing illegal drugs. Which brings us to the second type of federal court, the appeals courts. There are 13 courts of appeals in the United States. If a person disagrees with the outcome of their first case in one of the district courts, they can appeal that decision to one of the federal courts of appeals in their region. The third type of federal court is the Supreme Court. The Supreme Court is the highest court in the country, and their primary job is to interpret the Constitution. This means when they are hearing a case, they have the power to read the Constitution and determine what it means and if it has been broken. The Supreme Court only hears about 100 cases per year, and they can only rule on what we call real cases. These are cases involving real people with real legal problems, not hypothetical situations that haven't happened yet. If the Supreme Court could use court cases to make up laws for hypothetical situations, they would be legislating, or law writing, and that is Congress's job. Earlier, we learned about the federal appeals courts. Well, if a person doesn't like the decision of one of the appeals courts, they can also appeal their case to the Supreme Court. In fact, most of the 100 cases heard by the Supreme Court each year are appeals. However, cases involving states or cases between a state and the federal government can only be heard by the Supreme Court, not the other federal district courts or appeals courts. We call this original jurisdiction. The Supreme Court operates on a schedule. Usually they will hear cases for 2 weeks and then study those cases for another 2 weeks before they announce their decision. The 2-week period of study is called a recess. The decision the Supreme Court makes on a case sets an example for all similar cases to follow in the future. We call this a precedent. Judges working in the federal courts aren't elected. They are nominated by the President and approved by the Senate. They can also be impeached and removed from office by Congress. Which brings us to checks and balances. Congress's right to impeach federal judges is a check or power the legislative branch has over the judicial branch. The President's right to appoint federal judges is a check the executive branch has over the judicial branch. And the Supreme Court's ability to declare an act of the President unconstitutional is a check the judicial branch has over the executive branch. Checks and balances keep any one branch from becoming too powerful.